For many years, I, as a parent, have been concerned about the obscene and pornographic materials that find their way into our school and public libraries. While I believe that this is happening inadvertently, the increasing frequency of exposure of our children to obscene and pornographic material in places that I, as a parent, consider safe and assume are free from these kinds of harmful materials is alarming. We can and should expect a level of vigilance in protecting our children from obscene and pornographic materials, particularly in public and school libraries in our communities.
You indicated in your prefatory remarks that you consider this an objective standard, which I'm glad you addressed because that was one of my concerns, was the subjectivity. But I guess by way of illustration, I'm curious because as I look at this, one of the books that came to mind was a youth classic. I think it's Judy Blume's Forever, which I think is actually how I learned what I knew at the age about male sexuality, and it depicts a teenage boy who has erections and masturbates and wet dreams, and it's kind of intended actually for a younger audience to introduce these concepts. I am curious whether that would run afoul, because it seems to fall explicitly under some of these categories in terms of overtly describing sexual excitement, masturbation, etc.
Mr. Speaker.
Is that your understanding?
Speaker, would you put the House at ease?
Yep.
Thank you. And I'd like to have majority and minority leadership as well as the sponsor.
Come on up.
As I was looking at the super secret folder that we were suggested to look at, knowing that this debate was coming, so I went and looked at the super secret folder. I did not find Playboy, I did not find Playgirl, I did not find Hustler, and I'm sorry I don't know any of the other magazines besides those. But I didn't see any of those there. The things that I saw, while I would say that perhaps parents should, there would be wisdom if a parent or a grandparent was taking their child or grandchild to the library, perhaps, depending on those parents' own individual value sets, that might be something that they should be reading with their child. Personally, and this is all going to depend on age too, for my grandchildren, some of them are old enough that we can probably have some healthy discussions about some of the literature that was contained in the folder. Some of them are way too young to be exposed to that material. And in our local libraries, those are going to be set apart. So again, I feel like our libraries are doing a good job, and what we don't want to have are our local libraries being subjected to subjective claims.
I really want to underscore what we've heard, but I think we really do have a pretty fundamental subjectivity problem here, particularly when this section is removed. I mean, it's kind of axiomatic in criminal law that you run into a due process problem when you have vagueness. Criminal laws have to be crystal clear. You need to send a bright red line to the public on when they are violating the law and when they are not. And you really can't be mushy on that without running afoul of due process guarantees of the Constitution. And I think that, part of what saves the original statute, I don't actually know if the original statute would really survive a really hard run at it under due process questioning, frankly. But I think without this Section D, it would really be in trouble. Because part of what makes it okay under Miller, part of what makes it okay under due process is that it does have this protection. Because you have this vagueness where you don't really know what someone might consider harmful to a minor, but at least you have this penumbra, this safe harbor, where if you're involved in the educational arena, you don't have to worry about it. And you don't have to worry about whose opinion is what and who thinks what's harmful. You strip that out, and I think you create a real constitutional problem. And frankly, I think our debate here really kind of proves beyond any shadow of a doubt that we have a real subjectivity problem here. I provided a brief overview of what is considered a classic of young adult fiction and used the words of the statute, and I was all but gavelled down. Clearly, under this, that brief, I don't think it would violate Miller, but it clearly didn't accord with the prevailing standards in this adult community. So I, as I stand here, have absolutely no idea where that line lies. Truly don't. I tried to get a question from the bill sponsor. I don't know. I truly don't know as I stand here. How in the world is any librarian facing potential criminal sanctions going to know? They absolutely cannot, and I think as a result, this is absolutely unconstitutionally vague and ambiguous, and it's very unfair to our librarians and educators to ask them to operate in a world where they have absolutely no idea what is legal and what is not, and what will send them to jail and what will not.
Mr. Speaker, to debate in favor of the bill.
Gentleman has the floor.
You know, some of that material that was sent out to us in State Affairs, I looked around the room. People are opening their folders and throwing them across the desk. So I opened mine, I got to page 2 or 3, did the same thing. It was so obscene, I can't unsee that. And I have some experience with this stuff, and I'm going to explain that in a bit. I would rather my 6-year-old grandson start smoking cigarettes tomorrow than get a view of this stuff one time at the public library or anywhere else.